these lawyers advertising on television, you pay nothing up front unless you recover. That's a contingent fee contract. He's simply saying, let us try your case, let us develop your case, and if you win, then we're going to take a percentage. So you want to ask the question, what's the typical percentage? Well, it ranges between 25% for settling the case without a lawsuit, all the way up to 50% through trial. My typical agreement is the following. 33% of every dollar comes to us if we settle your case without a lawsuit. If we have to file a lawsuit on your behalf, then we get 40%. So of every dollar, 40 pennies come to us, 60 pennies go to you if we win. If at the end of the trial or end of the case, you get nothing, then the lawyer gets nothing. That's the risk of contingent fee. Just recently, I tried a case on a contingency fee basis. The client was offered a chunk of money. I told her, please take the money. She wouldn't take the money. She went to trial, got a jury verdict, actually poured her out. She didn't get anything. And I'm talking about millions of dollars she left on the table. The point is this. That's the risk of the contingent fee contract and why lawyers are permitted to take a percentage. On an hourly fee basis, that's where the lawyer says, I'm not sharing in your risk. You pay me as we go. So, and the typical rate for a young lawyer between 1 and 5 years is somewhere between $175 to $350 an hour. For lawyers 5 years or older, the rate can vary wildly, between $350 an hour all the way up to $1,000 an hour. And I'm not about to tell you what my hourly rate is. But I can tell you that it can get very high in terms of the hourly fee rate, and that means that the client has to pay on a regular basis for the services. Now, let me tell you the harm of a contingent fee contract. A contingent fee contract, when you sign it, says generally you convey and assign to the lawyer a percentage of your case. That is, you walked in the door 100% owner of your case, you signed a contingent fee contract, you just gave away 33% of your case to your lawyer. And the reason the lawyer does that is to protect herself or himself in case you walk the case. Say they do all the work, they worked on it for 4 years, and then all of a sudden you just get mad at them and walk away. The lawyer, in order to protect her or his interests, says, I'm sorry, 33% of your case belongs to me. And so if you go out and hire another lawyer, that lawyer is put on notice that 33% of the recovery has to be paid to the first lawyer. You may ask, how is that? I could end up paying 2 lawyers. Exactly. You absolutely can. So the only way that you can get rid of that contingent fee interest is if you fire that first lawyer for cause. Say she has done something wrong. She has violated a major rule. She's disclosed a secret. She's stolen your money. She settled a part of the case and didn't tell you that she had your money. I've heard so many horror stories of people saying, this lawyer settled my case, took my money, dismissed my case, and I didn't even know it. If that has happened to you, you let us know, and it's our duty as lawyers to report that lawyer to the state bar to have them disbarred. The fastest way for you to lose your law license is to steal your client's money. That sounds pretty straightforward as to why you need to be fired. But in that instance, Professor Hemphill, if the client fires you for cause, the contingent fee interest is then terminated, or at least you have a solid argument that is terminated because you could not stay with that attorney. Would that be a fair statement?
That's a fair statement. I guess it depends on what the misconduct is, because then you get into misconduct. And so it depends on what the agreement says. If there's something there that says, even if we're terminated, you repay us for fees spent out and things of that nature. So you have to be careful about that too as a client.
All right. So now we know that even if you fire the lawyer, you still might have to pay him or her. The next is if you are a criminal defense lawyer. And I can tell you what the word down at the courthouse is if it's a criminal defense lawyer. That is, get paid before your client gets jailed. In fact, I know one lawyer, and I definitely will not call his name, said, until I get paid, I don't want you to dismiss the criminal charges against my client. I'm telling you what I know, not what I heard. I thought that this was unethical for this lawyer to say, the DA was going to dismiss the charges, said, do not dismiss these charges until I get paid. The point is this: criminal defense lawyers typically say pay them up front because they don't guarantee that you won't go to jail. And at least based on my experience, if you go to jail, your ability to earn income kind of diminishes while you're there. And that's why defense lawyers, criminal defense lawyers, ask family members or whatever to put up the money to pay for the defense of the case. That's totally different from a contingent fee contract because they are asking to get paid up front for the representation. Now on the hourly fee, whatever rate it is that y'all have agreed to, the lawyer is entitled to be paid the agreed amount. But what you should look for is he or she charging too many hours? It's one thing to say, I'm only paying $175 an hour, but if the lawyer is charging you 40 hours a week, that might be excessive. Now, is there a rule, Professor Hemphill, on how reasonable the attorney's fee must be?
The model rule is 1.5, and that goes into fees, and fees have to be reasonable. So it depends on the matter. If you have, for instance, just for our listeners, a car wreck situation, and it's on an hourly rate, which typically that's not the case. But if you have a car wreck situation, it's on an hourly rate, I wouldn't expect the lawyer should be billing 40 hours a week.
I can tell you that if you have a lawyer that's billing you 40 hours a week, find out what other business he or she was working on, because you'll start finding that lawyers are billing like 300 hours a week, and you say, how can you do that? You don't have enough work hours to do that. But so the point is this: be very diligent in looking at how many hours the lawyer is charging you, not just the rate that they are charging. I'm going to conclude this section by talking about causes, things that cause you, that you can fire a lawyer for. Telling your secrets, automatic termination. Stealing your money, automatic termination. And just so that you know, when the lawyer receives your money, she or he has to put it in a separate account. They can't borrow your money and put it in their account. They can't spend your money. That's your money. It has to be put in a separate account, and he can't commingle his money with your money. You have the right at all times to know how much money he has collected or she has collected on your behalf. And any lawyer who hesitates to tell you how much money they've collected, they have violated their duty of communicating fairly and honestly with you. You have the absolute right to call in and ask the lawyer about your case. Now, if you're incessant, if you're just calling all the time, some lawyers might say, listen, nothing new has happened, and they communicate that to you in writing. You should expect a lawyer to communicate with you generally within 30 to 60 days, sometimes 90 days, in that kind of interval, because the cases are not going to settle right away or resolve right away. Some cases last years. I have one that's 11 years old. You can imagine if the client were calling me every month, how much communication we'd have in that case. The point is this: you have the right to reasonable communications from your lawyer, and if the lawyer says, well, you're calling too much, this is the response you should tell the lawyer. You're going to ask me for decisions to make in this case, and if I'm not fully informed, I can't answer or give you my advice. So if the lawyer's talking about just let me handle your case, then no, you're going to ask me for decisions, and I want to be fully informed before I make those decisions. Any lawyer who gets upset about that, you need to look for another attorney. So I think that those are that's just an overview of what factors you should look at to hire or fire your attorney. And if you have a trial lawyer, ask them when is a hearing, and then go watch them in the courtroom. If you start seeing the lawyer coughing and getting dry mouth in front of the judge or in the court, you know you need another horse. How about that, Brother Hemphill?
That's accurate.
I've seen them, boy. I've seen a young lawyer jump up, and I mean, they just started coughing in front of the judge, and I knew that there was just nerves. They were just scared, and I was saying to myself, I fear for the client, because you're going to need a lawyer who's very comfortable in the courtroom, especially with a trial lawyer, because we are carnivores. We're looking for that weakling in the courtroom. That's what we do. And I don't mind telling you, I like to be a Tyrannosaurus Rex when it comes to looking for the weak lawyer in the courtroom. Now, there's some great lawyers out there, too, and I'm sure they're Tyrannosaurus Rexes as well. But listen, you can call in. We can take your questions on lawyer problems. Don't give us any names. I don't want to talk about any lawyer names, but if you want to talk about a problem or complication with your attorney, now is the time to do it. The number is 713-526-1230, the new KCOH. I see that we have callers standing by, and we're going to be with you in just a second. We'll take this call. Caller, you're on the air.
Good morning, Mr. Hall. How you feeling?
I'm doing well. Good morning.
Good. Hey, the mayor's race, man, was real good. And I would just like to thank you for running, man, and being a pillar in the community. And even what you're doing right now, I think you should hold a big legal forum, if you can. You know, I think you give a lot of good information to a lot of people that really don't know the law. And I think that'll get the community a little bit insight in who Mr. Hall really is. Just get a little bit more personal with the community. That's just all I wanted to say.
Well, thank you so much. In fact, I really appreciate your comments. And if we can have an opportunity to have a legal forum or just an opportunity for us to get to know the community and the community get to know me, we're going to do that as well. That was not my last run for office, public office, but I better be quiet on that right now, and we'll talk about it a little bit later. But thank you so much for your call. All right, we have a second caller. Caller, you're on the air. Good morning.
Good morning. Yeah, a quick question. I want to ask about a lot of people, like these banks, like Chase Banks, Wells Fargo, and Bank of America, have been taking insufficient funds and overdraft fees from a lot of people's accounts, like $2,000 or $3,000. But if there's an attorney, I guess, filed in other states a class action lawsuit, and when the settlement ends after 3 to 4 years, the clients have got like $8 checks and $10 checks. How is the attorney wind up getting that certain percentage of whatever?
I'm going to tell you the tragic reality about class actions. Class actions are really the tools for the lawyers.
That's right.
And quite honestly, the reason and the rationale behind it supports how the lawyers get paid. The lawyers, the theory is that because individual claims are so small, any one person won't go and file a lawsuit, a multi-million-dollar lawsuit against, say, a bank because they can't afford it. Because all they're entitled to is probably $20 or $200. So you don't file a, $3,000 lawsuit just to get $200 back. So they lump them together in a class action. But what happens is then the lawyer and the representative party are the only ones before the court. And then they go before the court and say, Judge, we can now have a settlement. And the defense likes the settlement because they get rid of a ton of lawsuits just by paying the lawyer some fees and expenses. And tragically, that happens too much because there's no one there to fuss at the lawyers and say you're taking too much money out of the coffer. And so as a result, you get exactly what you've just called about, where at the end of the class action, you get a certificate, or you might get a little gift card to buy more product with the offending defendant, and the lawyer walks away with $20-30 million in attorney's fees. Unfortunately, that happens too often, and the only recourse you have is to go out get an assembly